Homestead rights and divorce in Illinois. Owning a home is often considered a cornerstone of the American dream. In Illinois, specific laws are in place to protect a homeowner's rights, especially when it comes to homesteads. These protections become particularly relevant during a divorce. Understanding how homestead rights work in Illinois, especially if you're facing divorce, can clarify what happens with your home. Legal framework of homestead rights in Illinois. A homestead, by Illinois law, is the primary residence where a family lives. The concept of a homestead is grounded in ensuring that families have access to a stable home. Under Illinois law, declaring a property as a homestead offers certain protections, preventing one spouse from evicting the other from their shared home without consent. This is established by laws that state, neither the husband nor wife can remove the other from their homestead without the consent of the other, unless suitable alternative housing is provided. These provisions protect family members from potential financial struggles or conflicts that could otherwise force one spouse out during difficult times. During marriage, one spouse cannot unilaterally sell or waive rights to the home without the other spouse's consent. For instance, if you decide to sell your home, both spouses generally need to sign off on any agreement. Illinois statute clarifies that no deed or document is valid in waiving homestead rights unless both parties sign explicitly for such a release. Understanding how homestead rights affect divorce proceedings in Illinois. Homestead rights apply only while a marriage is still legally recognized. Once divorce proceedings begin, these protections are no longer fully applicable in terms of property division or eviction. During divorce, the court may decide the best way to allocate or dispose of a home based on equitable distribution and the specifics of each case. Illinois law grants the court authority to distribute the homestead estate according to what's fair and just under the circumstances of each couple. How homestead rights are defined and applied. The homestead exemption in Illinois allows homeowners to protect up to $15,000 in home equity from creditors. For married couples, this amount increases to $30,000 if both spouses are listed on the property deed. This exemption can safeguard a certain level of equity, protecting families from losing their entire home value due to foreclosure or significant debt. This means that in the unfortunate event of foreclosure, each individual may retain a portion of the equity if they own the property jointly. If one spouse holds the title and the other maintains the property as their primary residence, Illinois case law indicates that only the title-holding spouse can claim the homestead exemption. However, if the title-holding spouse dies or leaves, the non-title-holding spouse may retain homestead rights to continue residing in the home. Under Illinois law, children living in the home may also benefit from homestead protections until they reach 18 years of age. There are limitations to the homestead exemption. It does not apply to property taxes, assessments, or certain debts related to the property's purchase or improvement. This means that while homestead rights provide significant protections, they are not absolute when it comes to all financial liabilities tied to the property. Owning a home is a major milestone, and knowing your homestead rights is crucial, especially during divorce. For those navigating a divorce, understanding these rights can make a significant difference in how property is handled. To learn more or discuss your homestead rights during a divorce in Illinois, contact our experienced team at the Chicago Family Law Firm located at 1165 North Clark Street, number 700, Chicago, Illinois, 60610. Schedule a consultation by calling 773-334-6311 to protect your home and your rights.